for staying with us. So I have here with me in the studio Dr. Yemi Omodele, a legal practitioner. Many thanks for being on the show with us.
Thank you, and I say happy 100 days in office of the present administration, listeners at home, and the world at large.
Okay, all right, thank you, sir. And then we have Charles Ajoya, Senior Advocate of Nigeria, the former Delta Attorney General and Minister of Justice. He joins us live from Warri, Delta State. Many thanks for being with us on the show at this time. Okay, all right, let's just dive right into the topic already. Let's start with what's your assessment of the presidential election petition Tribunal Justice from the judgment. How would you assess it? Okay, I think we do not have his audio at this time. So now to Dr. Yemi Omodele. Generally, if you would give an assessment to the judgment of the petition tribunal, what would you give it?
Well, to be sincere, the justices had done the job given to them by the Constitution and Nigerians. I stand to be corrected. It will be the first time in the history of Nigeria judicial system for a court or a tribunal, a panel, to deliver marathon judgment for several hours with a view to get to the root of the issues before the court. I personally salute the courage of the justices. They've done their job. The persons who may not be too comfortable with the findings of the court they still have the second chance. They can still go to the apex court. So they have the constitutional right to exercise.
Okay, all right. And then,
but as far as I'm concerned, the judges have done the job expected of them.
Okay, all right. And then let's go to Charles Ajoya, Senior Advocate of Nigeria. Once again, apologies for the format time. What's your assessment of the judgment from the Presidential Election Petition Court?
Well, I listened to the judgment being delivered. Sorry, can you hear me?
Yes, I can hear you. Please.
Okay. I listened to the judgment being delivered, and of course it took a long time, and I expected that. Having regard to the number of petitions they were considering, and like my friend said, well, in the history of this country, I think we've had similar lengthy judgments because of the issues that were raised. So it was expected. But I must salute the courage and the painstaking manner in which they reviewed the case and came to a decision. And no matter how the judge sits to decide a case, in most cases, a party will be satisfied, the other party will be dissatisfied. But I know that in very few cases, you have both sides being satisfied with the judgment. I think in the days ahead, we'll be able to say how much the other side, the losing parties, have accepted the judgment. But so far, I think they've raised and decided novel points, particularly first on the amendment decree, the amendment petition, electoral act on the use of the levers. Indeed, before the election, the thinking was that, oh, that's going to be the magic wand. But the interpretation of it has left everybody disappointed that, well, the legislation did not do a proper work on it. That's the thing. You cannot blame the court. It's the legislation you now blame. They made the law in such a way that INEC had discretion. So if they have decided that, because the law is what the judge says the law is, and I think it's they only interpreted the legislative intent, which gave INEC discretion to do that. I know the matter may go on appeal, and if it goes on appeal, perhaps the final court will have the final say on it. So far, I think that we give some kudos to the judges for a job well done.
All right, very well. Thank you for that. Now, if we look at how the petition, well, how the judgment went, a lot of petitions brought against President Bola Tinubu were struck out. Some where they noted that perhaps thuggery disrupted the election processes there, or some places of alleged vote buying. They failed to specify the particular ward in maybe the local government area and the state that such happens. So it makes one wonder, what were the lawyers doing that they could not advise their clients that all these evidences that you have would not be admissible in court?
Well, you see, I'm sure that the lawyers themselves are aware of this, because they are eminent lawyers by their own rights. But I think the difficulty they had is that they didn't have the full instructions, or their clients couldn't provide the full instructions. And again, that could be understood, particularly with the number of days you have to file this election petition. You have 21 days to do that. And we're talking about the presidential election, which covers the length and breadth of this country. And for you to get that information and plead within 21 days, I think it's almost impossible to do that. And so I'm sure the lawyers are aware of it, but they took a chance in the whole process, because even in ordinary cases, you don't plead vaguely. I mean, you must plead and give the material facts. So if you're talking about particular regularizing the particular polling units and you don't mention it, you don't expect your opponent to go fishing to know what your mind is. So the judges were right, I think, in the approach they took on that. In my own
hopefully we'll be able to reconnect with them. But now to Dr. Modele.
Yes.
Now, the thing is, like what he has said, they have just few number of days to get evidences put together to present in court. Would you not say that the petition tribunal in a way has been fashioned that it suits the sitting governor or president or whoever it is in the National Assembly, that it gives very little room for people to gather the facts and evidences during the election for them to be able to present it in court, and it would be to their favor?
You see, globally election petition is time-bound. So the fact that petitions were filed and that it is time-bound was not known after the election was conducted. It had been known before the election was conducted. Therefore, they should have strategized ahead of the conduct that, okay, let us be gathering our evidence in case we don't win. But in case we win, this is that. So they should have started from day one. Even before they obtained the nomination forms, they should have started preparing towards the D-Day. Not after the election was conducted before we started running head-tasketa. So the stamp ban is known to everybody. So it's not an excuse, to be sincere. But I can say that maybe lack of proper strategies by the politicians, that must have caused them one or two things. Then aside from that, if you look at it from one angle of gathering evidence, documentary evidence to be tendered at the tribunal, the doors to the offices where those documents are to be obtained, they are widely opened. Now, we have 36 states of the Federation. For a serious and determined politician who wants to challenge the victory of his opponent, and by the rules of the election, a political party must cut across all the states of the Federation. It suffices to say that a political party must have representatives in all the states of the Federation. Therefore, to gather evidence across the states of the Federation shouldn't be a difficult issue. You get in touch with your state chairman at your state, at the state level, whether Nasarawa, whether Kano, whether Jigawa, whether Cross River, Delta, Bayelsa, and the rest. Then the legal team will meet. These documents can easily be gathered, and then the case will proceed, and they can still file within the time specified by the law.
Okay.
Now, with due respect to persons hiding under the guise of time ban, I decline, because when you are aware that this is what the law says, 21 days, whether 21 days, whether 40 days, you are to work within the purview of those days. So, and there is no room for extension. So, since you are aware that there is no room for extension, you should have started even before you obtain your nomination forms. That in case, if I lose the primary, if I lose the main election, what are we doing? You set up your legal team. Okay. I can say that there are some of the politicians that are contested that have such legal team. Yes.
Okay, all right. Let's hold that thought for a while. Please let us go on a short commercial break. And when we come back, Firecrackers continues. Please stay with us. Charles Ajoya, Senior Advocate of Nigeria, former Delta AG and Minister of Justice. Many thanks for being with us. And now that we've established some of the things that might be wrong with the judgment, or things that happened that accumulated to the judgment, what changes would you like to see in the petition court for the future? Because we have other elections coming up in just few months, and then of course whenever there is election there's always petition. So what changes would you like to see?
Well, your question, I'm not quite clear what you said. Is it changes as per the petition court, election petition tribunals? Well, I think that if I'm going to answer that question, I'll take it from a point you may not expect. Now, the problem we are having with these election tribunals is that they are taking the time of other matters and the rights of other people that are in court. I think that this country, we are large enough to have retired judges who can act in the election tribunals so as to give the ordinary courts, the other civil courts and criminal courts, the opportunity to work on side by side. Because speaking for me, for the whole period we're going to have these election petitions, virtually other matters are put on hold. Criminal, civil matters, commercial matters, these are also very important for this country. But be that as may, I think that the composition of the electoral tribunals, the qualifications made, the presiding justices, I think they have men of character that preside in these tribunals. And that's what we expect. We don't expect anything less than that. Judges who have knowledge, judges who have sense of justice, and judges who understand the law and the ecosystem in which elections are done. I mean, if they preside over these election petitions, I don't think we'll have problem with it. Judges that are incorruptible, those are the kind of persons we require in these to sit over this election. So, to that extent,
justice is blind. In fact, there was one thing that I felt like was cleverly carved when they said that the one who is usually on trial in a court proceeding is the judge himself, because both the victim and the one they are accusing, both of them know what they did wrong. But then they leave it to the judge that, okay, now you figure out what is going on. You figure out. So now, Despite the fact that, in fact, sometimes these judges might sense that there might be some little mischief going on in maybe gathering of evidences, even some that are circulated online, but then there might not be enough proof to say that, okay, yes, this is what is going on here at this particular point. And the judges having knowledge of this, but then they choose to look the other way because they have to consult the constitution and what the law has to say about that point. Do you not see this as politicians playing on the intelligence of our judges?
No, you see what happens is that the judges, they work based on the law. Now, there is a law guiding their operation, there is a law guiding their conduct, and there is a rule also guiding the court proceedings. These are the things which they work with. Now, a judge will not go outside the scope of what the law says. If law says file your petition within 21 days, and you now file it maybe on the 28th day, a day to the expiration. Now, you are now hiding under the pretense that the days were too short. You see, the legislators, they made the law. And the duty of the judge is to look at whether this law has been complied with or not. So the judge cannot suo motu amend that law. So unless and until such a law is amended, before the judge can say, okay, this is the law that guides me. So it will be very, very wrong of any judge to go outside the scope of the law, and that is what we call grounds of appeal. When a judge goes outside what the law says, you see lawyers, they form grounds of appeal, and it goes to appellate court. Definitely, it will be an exercise of futility. But when the judge works within the purview of the law, go to court of appeal, go to Supreme Court, it may not make a change. Now, a judge does not assume what is in your mind. So assumption has no place in the rules. So you cannot expect a sitting judge to assume, say, this man was unable to get this document within 21 days. That would be a voyage of discovery. So the legislators, we elected our legislators at the National Assembly and at the State House of Assemblies. They are there, they pass the law. Those laws are either signed by the governors or Mr. President. They have represented us. And these legislators, they are part and parcel of these known and identified politicians. So if the politicians, they want any amendment to it, they can channel it through the appropriate portal of the National Assembly. It will be looked into and then amended. It is not a job of 2, 3, 4 persons. It's a job about 100 and something human beings and different committees, stages. So it's a work of intellectuals. It's not a work of soul-minded person. So it will be very, very wrong for somebody to say the judge will have, no judge will ever do that. No judge will ever do that. That is why you see, once the law says this, the judge will also look at what the law says. Now, the rules or the law says, the electoral says, okay, the conduct of election petition tribunal shall be done, blah, blah, within 90 days. And you see what the justices did. They ensured that within that 90 days, they wrap up everything and gave to Nigerians what they said they wanted. So if you are not satisfied, you also have a limited number of days to go and go on appeal. So if you appeal, then you get to go to the Supreme Court and look and say, okay, this is it, and make their own finding. That is how it is. That's how law works. Law doesn't work in a vacuum. So it is not the issue of, you see, if it is the issue of motor mechanics. Now, instead of you to use Toyota product brake pad for Toyota, you now see Honda spare part or brake pad. You now cut it in order to fix it for Toyota. It can work that way, but law doesn't work that way. You don't assume, you don't subsume, you follow strictly, and that was what those justices had done. They had worked within the purview of the law. They give it to Nigerians what they wanted. So people that are not satisfied, or people that thought that maybe there is one error one way or the other, they can take it to the higher court so that the justices there too will also look at it and also make their findings.
But do you not feel that would be a problem? Because in many instances,
Yes.
when it is obvious that one person is guilty of a crime, but then the person is left to go free because there are no evidences to actually pinpoint the person to that particular crime. Do you not feel like even as citizens of a country, we should be worried?
No,
because
no. Let me quickly correct one person. A judge is not an investigator. Yes. Now, for instance, let's say somebody commits a crime, maybe false. If the EFCC arrests him, or police or ICPC, and charge him to court. It is what, be it EFCC or Nigeria police, brings before the judge, and the judge will look at. Now you say this man has embezzled $100 billion. You came before the court, you gave evidence, then in the course of trial, there is no substance to nail the defendant. You expect the judge to say, okay, you are guilty, they will go on appeal. But if there is nexus connecting such a defendant to the crime, that nexus must also still be proved. It must be established before the court. Then the court will be able to say, okay, this man is fully involved. This is this, and find him guilty. But where there is no evidence that can warrant conviction, the judge has no option to let him go. Because the principle in criminal proceedings is proof beyond reasonable doubt. It is not proof beyond balance of probability. It's beyond reasonable doubt. So the judge is an unbiased umpire. He is there to do the work given to him as contained in the Constitution of FIRECRACKERS. He's not there. He's not an investigator. He's not the victim of the case. He has no any interest there. So if you know you want your case to be properly taken care of and to secure conviction, you must prove it beyond reasonable doubt. You cannot say somebody stole money without any evidence to show that he has stolen.
Okay, all right. Now it's back to Charles Ajoyo, a senior advocate of Nigeria. What role do you think INEC could play to assist this petition tribunal so that it won't be waste of judicial time? Because we've seen some people like the one that occurred for the National Assembly. One person representing Lagos for the House of Representatives, the person was dismissed from the office because it was found out in court that he was not qualified. Do you think that INEC perhaps should have helped eliminate those things so that we'll be able to save the precious time of the judiciary?
Well, I think INEC has a limited powers to do certain things, particularly the area which you are talking about now. Before the election, I mean, part of the pre-election process, candidates, nominations were done, and it was for the people to come out to object to such and for such nominations. And if they do not do that, perhaps INEC has limited powers to do that. But most importantly, I think that INEC, independent as it is supposed to act fairly to all sides. And when it comes to after election, INEC should be willing and prepared to bring out the documents that were used for the election with ease, so that the parties can make whatever use they want to do of these materials. Of course, I'm sure that INEC itself knows that after election, there are likely to be some disputes. There are likely to be some challenges. So these materials, they should have a system where these materials can be kept and easily accessed by either the victors or the vanquished in the election process, so that the whole process is transparent and nobody casts doubt as to the sincerity of INEC. Then number two, I think also that when things talk about irregularity and all, INEC is the umpire that conducts the election. I mean, INEC should be able to come out first to show how it conducted the election in that area. So if there are irregularities, it should be able to honestly point it out, because there are human beings there. But I'm sure INEC will not set out ordinarily to go and perform its duties in an irregular manner. And that is why even the law presumes that there is irregularity in the functions which they have performed. But I think Nigerians will be happier if INEC, plays a more transparent role in the election process. I know that they use ad hoc staff and all to conduct this election, but they should be able to monitor these things and keep their materials transparent for people to see, so people can trust their judgment in the whole process. I mean, we saw all that happened in some of the states after the election, how results were being declared on the other things. So these are not things that should be happening at this time when we talk about technology. The problem indeed is that we are relying so much on analog ways of doing things. People are moving on, and somehow we are not moving on. And so we are grappling with these things that should not really be a problem. And let me just say something here about the last question you asked my learned friend. No, you see, the symbol of justice. It's a blind lady with a scale, a balance, and a sword. Now, the role of a judge is to administer justice. It is not the role of a judge to go out and look at what is said in the social media to enable him to decide the case before the court. It is for the parties to bring their evidence. And the law says they are bringing evidence must bring admissible and credible evidence. So not only that your evidence is admissible, it must also be credible. So these are the things that we should look at. And for a lawyer taking on the matter, must also, while preparing his papers, must ensure that his client is able to give him, one, provide witnesses. Because you cannot start a case and finish a case without a witness. If you do that, of course, your matter will be struck out or dismissed. Then two, if you have the witnesses, what kind of evidence are they going to give? Are they reliable? Are they credible? These are the things that we should ask ourselves, so that we don't waste the time of the tribunal. I mean, the lawyers have made all effort, they did their best, but I think that we need to do more, and need to do more by advising our clients and evaluating matters before we put them in court.
All right, we thank you so much for sharing your views with us on the show. It has really been interesting. Many thanks for being with us on Firecrackers.
It's a pleasure, thank you.
All right, and that was Charles Ajoya, Senior Advocate of Nigeria, former Delta Attorney General and Minister of Justice. He joined us live from Warri. And before we round up, do you have anything to say in conclusion to all this before we move on to our next topic?
You see, particularly concerning what happened at the decisions at the tribunal, I just want to appeal to Nigerians that when cases are filed in court, one party will win, the other one will lose. Whoever loses has option to pursue to Supreme Court. Now, whoever has been aggrieved, they should make the consultation with their lawyers and ensure the needful is done, rather than turning the country into a war front via social media, series of stories, then inciting comments is not good for our democracy and for the development of this country. The country belongs to all of us. We have to join hands together to ensure that it is developed more than Europe. And I so say that Nigeria will be one of the best, if not the best country in the world years to come.
I strongly believe that too.
And that people that are running away from this country, the people who have fallen under the Japarism, they will see Japa come back and to come and see better things in this country. Now, I appeal to Nigerians who are aggrieved, they should do the needful whatever they want to do. And if they think that they are no more aggrieved, they should join hands with the present administration and let us move this country forward. We would not allow the country to be dragged into a dispute. Now, then you see, it's also an advice that to politicians who may have intention to contest in future, and those ones I'm aware that like 2 or 3 states elections will be conducted, I think this year, some next year. If you know you are contesting please strategize properly. Don't strategize on the pages of newspaper and media houses. Strategize intellectually. Strategize if it is in your favor. Strategize if it is not in your favor. Then you can know the next line of action. You don't strategize when you are filing your petition. You not started strategizing. That strategy will not work. You strategize before you participate in the election. During, then you'll be able to face any challenge that may come. So that is my advice to them.
All right, but I'm sure a lot of politicians would have learned a lot from this particular judgment. Now, let us